Today we're going to continue our discussion about trustee investments, and specifically, we're going to talk about the idea of using people to assist you in investment advice, and that's a relatively new concept, right? Because historically, we had a prohibition against delegation to other people, but we'll see how that kind of fits into our new model for investments. Anything, Ian, that you want to start with before we kick off?
No, I will say this. I get a lot of requests over the years for investment advisors who have some expertise in managing trust investments. And every investment advisor, of course, says that they're fiduciary-like and all of the things, all of the buzzwords. But it's one of those. They're kind of a rare commodity. And over the years, I've worked with various advisors to sort of get them up to speed, to make them qualify in a sense from that standpoint, so that they stand out, because things like the special status that they're given under the Trustee Act and the special requirements we have to have reports from them matter in our efforts, and we'll talk more about them.
Great. So, let's start with sort of the idea of getting advice. So our act specifically, and we'll see how it actually, some of the case law talks about it, but encourages a trustee, I would argue, to get advice on the investment of trust property, and to get advice and to rely on that advice if a prudent investor would otherwise do that. So that's the idea, that you go out and what kind of advice do you give to your clients, your estate trustee clients, on this issue?
So it's really important to differentiate what you're doing with the assets at the time and what kinds of assets you're dealing with. Of course, if we have those special circumstance assets that we talked about, where a cottage or a unique asset, that's one thing. But there's two aspects. One is a immediately distributable estate, and then a trust estate. So one that's got an ongoing trust, and that will drive the nature of the investment advice you need. Because, for example, if you have an estate that's immediately distributable, but it might take some time to liquidate some real estate now with the market softening and so on, one has to very seriously consider whether or not you just simply put that all into GICs and not talk about the diversified portfolio, because of course, if it doesn't go well and you don't have a longer term, you may be criticized for having put assets into the market. So that just illustrates that it's important to look at what is your mandate, and if it's an immediately distributable estate or not.
And most of the time when this comes up, I mean, I would say to my client, I think what you should do is call up your investment person, get them to provide advice about liquidating, understanding that, because everything's time, as you say, it's a time horizon that's so relevant to investment. So if you said to an investment advisor, I need to distribute these assets in a matter of a year or less, I think most investment advisors would say to you, well, if that's your investing horizon, you would want to liquidate and reduce equity exposure and volatility, et cetera, if that's the time frame, right? So that in itself, is built in. I would think if you sought advice from a capable advisor, that they would certainly, I think, have that in the back of their head.
Absolutely.
And so let's just talk about, there was some questions about who pays to get this advice. If you're and right now we're not delegating anything. We're still making the decisions ourselves as the estate trustee, but we're getting advice. And isn't that part of our job as an executor to invest, or can we get those fees that we pay to an advisor out of the estate and not reduce our compensation? What's
Well, this is it's a bit of an age-old question, and you've highlighted the two important cases there that talk about the fact that you can fees can be typically borne by the estate. It is a consistent objection, and certainly from the charity community, they will almost always object to any investment advisor fees. Now, again, you have to look at the nature of the investment advice being given. If it is a discretionary trust, or as you say, or you're making the decisions as the trustee, those are two different arrangements in the sense of not discretionary trust, discretionary account. So if you've got a long-term investment portfolio that you're carrying for a trust over many years, and your investment advisor is charging an annual fee, which is based on a percentage of the portfolio or whatever arrangements you've made. That's one thing that is usually attacked, and I think, of course, even the Young decision, but not as much the Miller one, can help us on that one. And then, but on balance, if you're making all the decisions and you're just acting as you're making the decisions, but the investment advisor is acting as the conduit to make the trades and so on, you're in very strong, in my view, very strong case to say that those should be borne by the estate, i.e. the expenses at the advisor level.
Right. And the Young estate is an interesting one. It was a trust company that was paying fees to an investment advisor, in essence. And the court still, and I think it was Justice Haney, who decided this, and said that, this was beyond the trust company's expertise. It required expertise from an investment expert, in essence, and awarded those costs and the fees from the estate and not deducted from the compensation for the executor. And the comments in both those cases say, look, investing is complex now, and it's not the old days when all you could do with the legal list, as we talked about the last time, was invest in T-bills and GICs. And so understanding now that there's so many complexities, so many obligations and duties on this, that you do need a professional. And so I think those two cases will help you if you're acting for the executor in getting the fees from the investment advisor paid from the estate.
Yeah, and it's, as I say, though, it's a very contentious issue, and it's typically one of the boxes that gets ticked when someone's taking a run at your accounts.
Yeah, and it's contextual, so it's not always or never, because if it's an immediately distributable estate, then it's going to be something different than an ongoing trust with complicated assets and big portfolios, et cetera. So then we have this whole new concept, really, of delegation of decision making, and that's different than getting advice. Advice is you get advice and then you make the decision. Delegation is, in essence, delegating authority and decision making to another person. And under the common law rule, Ian, and you may want to jump in here, the idea is that an executor doesn't have the ability to delegate decision making. Trustee doesn't have that ability generally for matters. So this is kind of a carve out, a specialized exemption for that.
Yeah, and that's that's an important common law limitation on executors generally, and the delegation of authority, and that ultimately, and I always use that example, that you can't delegate. You can delegate the authority to sign the check. Someone else could be signing the check, but you have to make the decision. Here, though, the delegation of the authority allows it, and it recognizes the complexities of investments, as you were saying, but it also recognizes the idea that mutual funds and pooled funds and so forth are going to be used in the investment community by a lot of us, and certainly should be used in the trust scenarios as well. And so that part of the community in the late 90s anyway got enough people in front of the minister at the time of the drafting of this legislation to pay attention to that reality. They had to actually come back twice to get it right, but the idea that you're going to allow someone who knows what they're doing so that you don't have to be on the phone every 15 minutes saying buy high, sell low.
And the other point here is that you'll see this is 27.1. So you obviously it was an amendment, and it's someone in, but it's not just you can't holus bolus delegate. It's really a question of whether a prudent investor, again, it imports that prudent investor standard, would do that in accordance with, and you see these sort of objective ideas, ordinary investment practice. To do that. And so, you know, you're gonna, in a case like this, if you were, Ian, I don't know if you've had any cases where you were challenged, where an estate trustee was challenged on their decision to delegate, but you would get I presume you'd get expert advice on that.
Yes, absolutely. It's pretty straightforward that way, but it's, again, you know, this isn't often litigated because the language is, this section 27, for these section 27 provisions are very much codifications of what needs to be done. And if you can stay within the parameters of these, they're not heavily litigated.
So the act actually says, look, if you're gonna delegate, we're giving you the authority to delegate. And if it's, you know, it's to the same extent that a prudent investor would do it, and it's in accordance with ordinary investment practices, you still need more, right? So you have to have, and this is quite clear in sub 2, a written plan or strategy. So it's gotta be reduced to writing. It's not enough to say, and Ian, jump in here, but it's not enough to say, you know, we talked about it and this is what we're going to do.
Yeah, and this is one of the the easiest things to do and the most often ignored. And that's, you want a full comprehensive report from your investment advisor on an annual basis as to what is your strategic plan. And what I do is I send section 27 provisions right to the investment advisor and say, here are the parameters. And I want you to give me an opinion in the context of those. It is a crucial document and everybody shrugs it off. But boy, when you're in litigation, you can't, I can tell you, it's like a hot knife through butter when I got that letter. And the truth is, nobody can second guess it, really, practically speaking. These judges don't have a clue on how to invest any more than we do. And they're not going to sit there and say, well, this BMO investment advisor didn't know what they were doing. If you put it in writing, you're almost certainly going to be protected.
Yeah, and it's really just there's a few there, A and B, acknowledgement of the fact that who you're investing for, and you know that that they've got the goal in mind. And any written plan, just to go back for a second, any written plan is going to, you know, have a strategy and, you know, assess risk and return. And it's, again, the prudent investor rule that's embodied in that. And so, you know, that's kind of makes some sense. And then there's this idea that there's got to be the agreement includes certain things, right? That they're going to follow the plan, and they're going to report to the trustee at regular stages. And we're going to look at the monitoring issue in a moment. But those two are requirements for delegation. So the Act is also concerned with the trustee's duty in selecting and monitoring the agent. Again, because this is a delegation of authority. So very important that the person that you pick is a good person and an appropriate person, and also that it's monitored. So basically, you've got to exercise prudence in selecting an agent. And there are no, that I've found, regulations under Section 30 that have ever been made about what is, you know, what compliance is necessary for those agents. But it's got to be an exercise of prudence. Have you ever had a case where there's a question about selecting that the agent was so bad or so unqualified that that it was the wrong pick?
No, I haven't actually, but again, it comes back to just, go safe, go with someone who's got a good CV or, even, I'm not saying you have to go to the banks, but someone that's got a good credentials behind them. If they've got a small shop in the basement of their house and they're doing the investments, you're going to leave yourself exposed.
What about the idea of picking somebody who's related to you? So you've got your brother-in-law is a great investment person, so I'm going to do that. Do you see any, like, would you give advice on that to say don't do it, or do you think that's okay? What would you? Because you do see that where all my investments are with my brother-in-law, and so they're gonna handle this too.
Yeah, I mean, look, this is where reality versus practicality comes in, right? I mean, if your brother-in-law's got the credentials and you're prepared to, you are carrying risk by doing that. It just gives it's easy fodder for someone to go after you on. Whether it's appropriate, whether it's fair, none of that really will matter. You're going to have to shake the brother-in-law thing, and at mediation they'll yell and scream about that like there's no tomorrow. So would I do it? Thank goodness none of my brothers-in-laws are in the business, because I'm not sure what I would do. It's a tough question, but it's not like a lot of the other services that are available in the estates area where it's a little more limited. If you're in a smaller community, you may have no choice but to work with one lawyer or another, because there's so few of us around there. But if you're in a smaller community, you can get access to financial advisors anywhere. And so they're not going to tolerate the brother-in-law quite as much for that excuse. You just better have a bloody good excuse if you're going to the brother-in-law.
Yeah, that's one where I always use the rule, blame me. I'm going to tell you, do not use your brother-in-law. And you tell your brother-in-law that your lawyer won't let you use them. You'd love to use them, but your lawyer won't let them. And that's value. You can charge the client extra hours for that advice if you're going to take the blame. But it's a good way out, because they may feel, and the same with the real estate agents, by the way, or anybody else. Boy, I always say, just go to somebody, no one, like a completely independent person. But so on top of the selection is the idea of monitoring, and this is quite formal. So there is the requirement of prudence in monitoring the agent's performance, which is an inclusive definition. So that's important. And we're talking here about, obviously you're going to review the reports and documenting this, right? That you've done that. Show a docket if you're an estate trustee that you've done that, or some sort of memo or something that you did that. And again, a lot of these are really a question of documenting what you did, right? There's also the requirement sort of you see that reviewing the agreement and reviewing the plan in essence, and looking at different things. So this is not a set up the plan and then forget it, especially in a ongoing trust, a long-term ongoing trust. You've got that obligation to continue to do that, and always consider whether there should be additional directions provided to them, or the appointment should be revoked, or those kinds of things. So now, do you see situations where you're going to get a second opinion, and how would you deal with that on a compensation issue? If you said, look, I've got this duty to monitor my agent, I think he's doing well, but I better go get a second opinion. Would you ever recommend that kind of situation?
Yeah, it's a very good question, because it does come up from time to time on large estates, and where there's big swings here, and the investment advice can mean a big difference. And what I have done is exactly that. I have done ghost opinions. I've had them monitor, and lots of investment advisors will do this for you. You give them a portfolio and you give and ask them to give you a report. It's worth considering on either larger estates or on estates that are running for, the 20 to 30 to 40 year runs.
So then we turn to the agent's duty. So again, the standard of care, and they have a duty to meet the standard of care, which is what would be expected in the person carrying on the business of investing monies of others. That's obviously makes sense. And then they've got to follow what you've told them to do as far as the agreement, and then follow the strategy or plan of investment. So we talk about the prohibition against delegation. We've got this special exemption that allows the agent, the trustee, the estate trustee, or the trustee to delegate to an investment person, an agent. But there is no such automatic authority to subdelegate that authority to someone further down the chain. And this is important because if you want to allow this, if the testator does want to allow this, and you see this quite commonly in whenever a trust company is appointed, that they want the authority to subdelegate from the person who's the initial delegatee. So that has to be in the will itself, or else there's a prohibition against it. And then we look at, and Ian, have you ever represented an agent on this kind of claim against them?
Yeah, I've got one. Yeah, I've had them over the years. Yeah.
Right. So we have a specific ability for a beneficiary to sue the agent as well as the trustee. So that's interesting, right? Like that we don't typically see. We think about the obligation being between the trustee and their agent, but in this case, it's extended to include a beneficiary. So if a beneficiary is upset with the way things have gone as far as the investment has been, how the assets have been invested or the return, or et cetera, the beneficiary can do that, right? So that's just an interesting option for beneficiaries when they look at the plan.
Absolutely, and it's rare though, for sure.
For sure. And then there's just the idea that there is protection if they act, if they conformed to the plan and it was a prudent investor would have done what they did. So again, they're not ensuring the success of a portfolio, or else everybody would go out there and hire a delegate to an agent. So that's the other point I want to make there. And that's this liability of an agent. So we do have a few minutes. Ian, any other comments on the idea of delegation and agency to make investment decisions for estate trustees?
No, I think that's all for now.
Okay. So we just have a couple of questions that, if you have a second, we're going to answer. And the first question was from the last one, where we were considering the prudent investor rule. And let's say we've got private company shares that are being held. What happens if it would be imprudent to continue to hold those private company shares? And is there a way to protect a trustee if they do decide to hold those because of the fact that it's a family private company, notwithstanding that it might not be a prudent investment?
Yeah, there's two angles. One is, of course, you can add it to the will, provision in the will.
Right.
And that's important drafting wise. And I actually heavily litigated that point fairly recently. And the second, of course, is to look to the unique asset exclusion clause in the Act that allows you to hold special assets. Those are two sort of off the top of my head easy solutions.
Right. And what about, we see it not uncommonly that people will put their especially trust companies like this, they put a particular advisor in and say to my executor, use this advisor. Is that binding on the trustee?
No, it's precatory, and it's something that for sure is used from time to time, but and I encourage my clients to use that language, but I always remind them that it's precatory and it's not binding. The executor ultimately has the choice.
And the last question is really, what about if the will has a particular investment strategy in it? So we see this sometimes. I mean, we've all had clients who want to control everything even after they're gone because they're the best. They're the best investors ever. And of course, one of the things I'm sure we all say to them is, look, you're not around to be nimble on this, and you have no idea what's going to happen. And so you're it's kind of a bit of a joke that you're even thinking that. You realize you're not here, right? But any advice on that, or what would be the effect if we put that in the will?
Well, again, I mean, there's only so much you can do on that level. In many respects, this is all pretty much. I mean, you see, wills are riddled with liability protections for executors, and typically the courts ignore them on a general basis. So, I don't think it's as you say, you're not around.
You're no longer there. I hate to tell this to you. You realize you're gone at this point, and it's kind of it's quite an issue for some people. They're like, well, I don't want I want my kids investing in this, and I want my kids investing in that, or I mean, it's just not going to fly. I don't think in that sense. So
it'll be seen as precatory.
Yeah, I agree. I agree completely. So the other thing to just mention again is that we have the webinar, or the seminar. Sorry, the in-person seminar on next Tuesday. We're thrilled. We talked. I know that we've got some great speakers lined up. Law Pro is represented by Judah Straczynski, and we've got Fritz Blaze, who's going to be there to talk about technology, just generally about how to adopt technology, along with Judah. So really great. Suzanne is going to be there. Ian, I'm going to be there. We've got a whole bunch of participants, and I think we're well over 50 people going to be there in person. So we're really looking forward to that. We also have an ability, if you can't be there in person, to stream. But Nick tells me that we're going to have food. So I don't know if that's going to induce anybody. I know, but it'd be great to see as many of you as we can, and chat, and we have lots of time to network and talk and catch up. So looking forward to everybody, if they can, making it next Tuesday, the 25th of October at 4 p.m. At 111 Peter Street. So right downtown Toronto. Ian, thanks so much. I'm off to speak at the summit, and hope everyone has a great week.